Welcome, all of you lovely law students here at Law School for Visual Learners blog. I'm Leslie Juveniquier, and today we're going to talk about defenses in analyzing your negligence hypothetical. So, a little bit about the blog. We do not promise perfection, we promise fun and a way to look at the world through a whole new legal lens using a visual understanding of the law. So today we're going to keep this section very short and sweet so you can get the overall understanding of how to approach your defense essay section. So let's share the screen. So I'm going to make myself a little bit bigger here so you can see me and all my hand movements. Okay, so let's take a look at negligence. So negligence is very basic and straightforward. We all know that negligence has duty, breach, actual cause, proximate cause, and your damages. But when we're looking at the essay portion and we're trying to explain how do we balance those damages and the responsibility of the plaintiff, we're also going to do defenses. So remember, in negligence as a body of analysis is very fact intensive, and there's two ways of looking at the facts. Particularly, we're looking at what facts are available to us and what facts are not available to us. And it's easy when you're, first studying and writing your analysis to just talk about what you see. But then there's also the facts that you don't see. And those are called inferences. So we can infer from the evidence, or the lack thereof, if you will, of the information in there. So we're looking at fact-intensive hypotheticals, and then we're also looking at the fact that there's a lot to go over in that as we now analyze negligence. So when we finally get to the defenses section, so we've done duty, breach, actual cause, proximate cause, damages, then we're going into defenses, then we're looking at, those three main bodies of defenses. And so this slide particular here, we're looking at the defenses, is giving you this major tip. Because in negligence, we're really looking at fact-intensive work. We're really looking at the breach, and then we're looking at causation. Most of the times it's proximate causation that we're having to spend a lot of time analyzing. So we finally get to the end of your essay, and if you're timed, you're probably sweating by now. These are the three things that we want to focus on: contributory negligence, comparative negligence, and assumption of risk. So when we go through these three, we want to address them quickly and give them their each subheading. So we go defenses heading, then we go down to contributory negligence, comparative negligence, and assumption of risk right under each other. And then again, rarely is a full negligence discussion necessary to establish a plaintiff's contributory negligence, because we know historically contributory negligence has been abolished in just about all jurisdictions, but the issue will still be raised as a possibility. So because we're testing what kind of law you know and how you can apply the law to the facts, you still have to touch base on that. So here is my visual slide on the three main defenses. So I want you to stare at this, pause it, copy it if you want, or you can buy a copy of my notes on the blog. But contributory negligence, comparative negligence, assumption of risk, where you can go down, like take it a step by step, like a staircase. Okay, you've got your defenses, and you're going down. So here we go. Contributory: any negligence on the part of the plaintiff that contributes proximately to his injuries completely bars his recovery. So we're talking about proximate causation. Remember the difference between the two. I'm not going to go into that right now, but we're sitting here saying that this theory says that, well, if in any way you proximately caused your damages, then you are barred to recover. I mean, no money's for you. But again, we have to acknowledge that and say that as a rule statement, any negligence on the part of the plaintiff that contributes proximately to his injuries completely bars his recovery. So if you want, you can take a screenshot, print this out, cut it into 3 pieces. And this could be a little, just a little game piece, if you will, to memorize. And you can just sit here and do that. Or you can cut it in half, in between, contribute this head, contributory, comparative, assumption, or riff, cut in half, make them their own, and then cut these apart and see if you can match them. Play a memory game, and that will be a fun way to learn quickly. Now, when we're looking at contributory negligence, you have that, and then you want to quickly analyze, was there a Hail Mary for the plaintiff? Was there an opportunity for the plaintiff to say, but wait, the defendant had a last clear chance to avoid the accident. Let's say I'm driving along negligently. Let's say I'm not driving at nighttime with my lights on my car. It's an old car, right? Maybe from the 80s where you actually had to turn on your lights. I'm driving along the road and I forgot to turn my lights on. The defendant didn't see me, right? I'm driving and I'm not breaking any laws except for the fact that I've broken the law of the lights. And let's say the defendant is a drunk driver, right? And they are driving on the wrong side of the road. They're driving on my road. I'm going north, they're going south, but they're going on the northbound road. So I'm going down and then they hit me because they couldn't see me. So the defendant could argue, well, Leslie didn't have her lights on. I couldn't see her, even though the person was clearly drunk. So she's not going to get anything. Obviously, that's up for the jury to decide. But we're sitting here going, but Leslie didn't have her lights on. If the drunk person had seen her, he wouldn't have hit her. So we're sitting here saying, okay, well, because Leslie didn't have her lights on, she proximately caused the accident, therefore there's no monies. I'm making this up. It's a visual example for you to realize, okay, what did Leslie fail at? So we're looking at how are we going to share the blame? How are we going to reduce that money zone? Well, the defendant saying, well, she didn't turn her light on. Yeah, I was breaking the law, but she didn't turn her lights on. So that's the reason why I hit her, because I could have avoided her. I avoided everybody else on the road, but I hit her because she didn't have her lights on. So we're creating that scenario here of how can the defendant get out of giving the monies. So here, the next one, we're going into comparative negligence. And this one is divided into 2 subsections, which you can see here in my little exclamation point. Warning, there's a difference between pure and partial comparative negligence. So when does comparative negligence apply? Of course, you're always going to analyze it in your hypothetical essay exam. The plaintiff's own negligence has also contributed to his injuries, but that does not completely bar recovery. I put it here just separate. Does not. Just so that way it's easy to remember. I could always just put it down here and say it does not completely bar, but I like completely bar separate. So that's the way I put it logically. So the plaintiff's own negligence contributed to his negligence. So yes, Leslie did not put her lights on when she was driving down the road. But the defendant was drunk and driving on the wrong side of the road. So he's breaking two laws to protect me, the class of persons that the laws were designed to protect. And so maybe 10% of the accident was my fault because I didn't have the lights on, right? But 90%, we're pretty sure that it was the drunk driver who's also driving on the wrong side of the road, right? So we're still saying, okay, maybe the 10% of the monies I don't get, but the 90% of the monies I get. So we want to sit here and just analyze that. So we're just saying, hey, yes, Leslie was at fault, but drunk driver is pretty much at fault. So you get the monies. Now let's go into a further analysis of what pure and partial is. So I take it to a further step, okay? partial comparative negligence, and then pure comparative negligence. And this is kind of like a mathematical equation for analyzing, you know, how much is wet, who gets wet, right? So remember, I want you to remember this. Comparative negligence also compares to multiple defendants, not just one defendant. So it's me and the drunk driver, right? Let's say that the city also put wrong signs on the highway and they were not clear. And there was a history of people, drunk or not drunk, getting on the wrong side of the road. There's a history. So let's say 50% of the city's fault and 49%, let's say 48% the drunk drivers and 2% was mine for not putting on the lights. Hopefully my mouth's right. I'm in law school, remember. And so the city can also be comparatively negligent in terms of like the actual blame, right? But remember, with joint and several liability, both the defendants owe 100% to the plaintiff. So I want you to remember that. But we're just simply just talking about these key distinctions here. So partial comparative negligence bars the plaintiff's recovery if the plaintiff's negligence was more serious than the defendant's in some states, equal to. So this is 50%. They say 50-50. If it's equal to or more, then no money is for you because you also caused the damage, right? So I put this 51-49 because in majority jurisdictions who employ partial comparative negligence, this means that if the plaintiff's negligence was more than 50% responsible, then the recovery would be barred. So if you see anything that seems really close, or if there's any kind of math on the hypo and it's really, really close figures, that's kind of like a trigger for you to go, okay, this is a partial comparative negligence situation. So then you would touch on that, okay? And then you have the pure comparative negligence, which permits recovery in proportion of the fault, regardless of how much the plaintiff was, but reduces it by proportion of the negligence. So let's say that the defendant was totally drunk, and let's say I'm driving too fast on the road, and if I hadn't had driven too fast, then the drunk driver would not have run that red light. I ran the red light, and the drunk driver was just drunk, didn't run a red light. I ran a red light and hit me. So then that person hits me. I ran the red light because I was speeding. So I still get some monies from this. So that's how the jury is going to look at that. And remember, comparative negligence is not a strict science, you know. I mean, it is a predictive science in a way, but it really is more like, what is the jury intuitively going to award? So we're not sitting here trying to calculate exact damages, but we're sitting here saying, you know, if the plaintiff was negligent as well, and how much would that be? We don't know the numbers sometimes. Sometimes they tell us the numbers, and then you just put the numbers if they tell you the numbers. But if they don't, then you just say that, well, if the court decides that the plaintiff's was negligent, but it would just, the recovery would be in proportion of that. So you have this little chart right here, a little pie graph saying, well, I was 40% negligent, so I'm going to get 60% of monies from the total damage. So this is a way of looking at how much everybody has to pay in terms of, like, you know, the credit, because I'm giving credit to the defendant because I obviously broke a law, so it subtracts that from how much they actually owe me. And then the last one is assumption of risk. A plaintiff may be denied recovery if she assumes the risk of any damage caused by the defendant's acts where she knew of the right and voluntarily consented despite the risk. So I assume the risk of damage caused by the defendant's act where I knew of the right and voluntarily consented despite the risk. So let's just say, okay, I'll tell you a story from when I was in college. One time I dated this really cute guy. He was in the military. He was like, he was in the, I think he was an Army Ranger. but he was a parachute guy. So he was like a risk taker. You know what I mean? He like jumped off planes like hundreds and hundreds of times. He had a very fast motorcycle. And one time we were going on the road and he goes over, I think he was like 130 miles an hour on the road. And it was just way too fast. It was scary. But let's just say in that situation, I wasn't wearing a helmet. And I didn't want to wear a helmet. And the law in that state says you can decide if you want to or not. Well, if he got in an accident and I decided not to wear the helmet, then that assumption of risk is a defense to him saying, yes, I was negligent. I was going too fast and got in an accident, but she decided not to wear a helmet. I told her to wear the helmet. She didn't want to wear the helmet. So it just depends on how much that is. If there was no head injury, no trauma, it was just physical trauma, you know, there is that to analyze as well. But I want you to think about the assumption of risk in any case. And sometimes, actually every single time, we always know this in legal hypotheticals, is that there's always going to be facts in there to indicate if there was some kind of risk that the plaintiff assumed. So you always want to put that in there. And that's your step-by-step analysis of going through your defenses in negligence. So you have, remember, go through them all quickly, address all of them, give them their own subheading. Again, contributory negligence, something you're just going to touch on, remember. Just make sure you know the rule. Make sure you know the sub-rule in the sense of the last clear chance doctrine. If there was any opportunity for the defendant to avoid injuring the plaintiff, throw that in there. Just quickly go into that. Comparative is usually where the bulk of the work is going to be. Make sure when you're analyzing that, you can take a snapshot of this or make your own card and do a side-by-side. Again, you can do a game saying which is which. And you can say which one totally bars the plaintiff's recovery if the plaintiff's negligence was more than 50%, then you know it's partial. If it's pure, doesn't matter what they do, they're going to get some monies, but you're just going to have to do a little bit more of analysis to show how much. And then assumption of risk. Take the visual of riding the motorcycle really fast, but not wearing the helmet, even though the guy says you should wear the helmet. I go, no, I don't want to wear the helmet. So and get hurt, and then I assume that risk. So I know that it's pretty much going to happen. You know, if you're going 135 miles an hour on the highway, there's a high risk of getting an injury. And if you know that you have the right and you voluntarily consent anyway, despite the risk, you've assumed that risk. So that's something that the defendant can say. So we're reducing the monies. It's really the way to get to, I say it in a funny way, but it's a funny way to remember it, you know, because I think there was an interview, I'll put an anecdote there, that John Legend and his wife, can't remember her name, really cute lady, Christina, I think her name was Christina? Anyway, Chrissy Teigen, I think it was her name. And so he talks about how when they got married, he made her sign a prenup, and now she's probably worth more than he is. And he said, you know, I didn't know that she was going to be more famous and more rich than me. They're just as much and just as rich. And then she just looks at him and she goes, don't touch my monies. So it is kind of like, if you look at the guy and the girl and the monies, defenses is really like, how can we reduce the monies? How can the plaintiff, how can the defendant reduce the monies they owe to the plaintiff? And it's like, yeah, but look, you know, and we're just analyzing all of that. So hopefully this has been helpful to you. This is just a fun little study session. You know, take these notes and then cut them up, play a game with them. Shouldn't take too long, maybe like 20 minutes just to read this over, play the game. If you get bored, put it away, play it another time. If you get tired, take a nap, wake up, do the game again. And play it with somebody that you know and love. Play it with a classmate, play it with your kids, play it with your partner, or a friend who's interested in learning the law. And I hope that you enjoyed this. And if you are a law professor or if you are a lawyer and you're going, that wasn't quite right, again, I'm a 1L student. I'm just here having fun. And if you have a better example, if you have a better illustration, especially a visual one or a video, tips, please send them to me, learnlawwithleslie@gmail.com. Visit us at the Law School for Visual Learners blog, lawschoolforvisuallearners.com. I'm Leslie Juvenet here, and I thank you for joining me today Hopefully you've enjoyed the Defenses to Negligence study session with me. Have a good one.